This hearing took a shocking turn when a lawyer accused the commission of hiding evidence. They say it was shared. He says it wasn't. So what's the truth? Watch this, and tell me in the comments, ambush or strategy? Subscribe for more revelations as the Madlanga Commission exposes hidden truths.
Commissioner, Mr. Chaskalson, we have not been provided with the charts or cell phone records of the informant to verify the dates on our records.
Chair, again. Sorry, my microphone has just stopped functioning. Switch around. Chair, can we just switch around here?
Perhaps we should adjourn. My co-commissioners' mics are also not working. Just very briefly.
This microphone does work.
Perhaps please respond to that, and then we'll have to take a short adjournment here.
Mr. Ngwato is correct. We haven't. This informant's chats with with Sergeant Nkosi certainly aren't in the bundle. They may or may not have been on the first memory stick. I didn't realize they had any relevance whatsoever until this evidence was given. When this evidence was given, I went online, or not online, I went to our record and went to see, one, whether this witness, the witness with the name that I remembered, came from Pakistan, and indeed the witness does, the informant does, and two, when those chats started. So I'm happy to download those chats, and Mr. Ngwato can re-examine on the basis of it. I didn't realize the chats were going to be relevant until this evidence was given.
Please remind me again, Sergeant Nkosi is scheduled to testify until when?
Well, until released. And we will certainly...
No, I'm asking in the context of we usually have 2, 3, or 4 days. I'm asking in that sense, Mr. Chaskalson.
I'm not sure what the arrangement was. We still have to get to a huge number of chats about the Tshwane Police Department, which were provided to Sergeant Nkosi about 3 weeks ago.
Thank you. And
it will certainly be more than a day.
Okay, thank you. Mr. Ngwato?
Chair, I have a serious problem with the response that Mr. Chaskalson just indicated, and I'm getting, every day surprised with new information, new documents. And now he says to you, there's still a lot of questions to come about Tshwane on documents that were provided to us 3 weeks ago. That's not correct. The documents on Tshwane were only delivered on my office this Friday. And I did not make an issue about it. That forced me to then change my entire weekend to then accommodate that. And now it comes to you that these documents were given to us 3 weeks ago, which is incorrect. They were delivered to my office just this Friday, and I made peace with it. Yesterday, new documents were now surprisingly brought up, and I raised that issue. I was promised to get the documents during lunchtime, which I did not. They sent it to me 9 o'clock at night. Now, just as we are continuing with it, new documents tried to slip into my files this morning. And now there's suddenly another file of documents. This cannot be accepted. It cannot be that they were not aware that this matter will come up. But if they knew and they planned their line of questioning in terms of this witness, they should have then provided us with the necessary information. How do I then consult and guide this witness with information from time to time as we proceed? New documents have been raised, documents have been delivered at night. How do then I continue to be able to assist if I don't have the necessary documentation? Thank you, Chair.
Thank you, Mr. Ngwato.
Chair, I do need to put something on record.
Just a minute, I'll come to you just now. Yes, Mr. Chaskalson.
Chair, these documents, the Tshwane documents, which Mr. Ngwata now says he saw for the first time on Friday, the documents were provided electronically. I'm about to get the exact date, but it is, to my memory, it was 3 weeks ago. I may be wrong on 3 weeks, but it was certainly not Friday. I'm going to get the exact date.
Were they part of the 1,300 and something?
No, the 1,300 were back in before February.
Yes.
These were a supplementary batch.
Yes.
That were given once we realized the relevance of the Tshwane documents. And when we did, we made them available electronically.
No, I wanted my co-com to just check their mics. Are they still not working? Oh, working. Oh, okay. Yes, sorry about that.
They were made available then, but we didn't print out a hard copy bundle. What Mr. Ngwato got was the paginated bundle on Friday. The documents forming part of the paginated bundle had been sent to him electronically weeks before Friday. So his complaint that he hasn't seen these documents before is factually incorrect. Or if it's correct, it's because he chose not to look at the documents sent electronically. What he got on Friday was the paginated bundle. In relation to this...
pagination of what was given to him electronically
earlier,
already.
Indeed.
Much earlier.
It's the bundle was sent to him on 3 March. It's 2 weeks. It's not 3 weeks. Why I referred to this set of chats now is until the witness explained the photograph with reference to this informant, I had no inkling that that the chats with the informant were going to be of any relevance at all. Now, what we choose to give to a respondent is in part governed by concerns of fairness and relevance. If I were to give, I'm quite happy to give Mr. Ngwato everything that we have downloaded from Sergeant Nkosi's phone. But that will be thousands and thousands of documents which he will not be able to work through in a systematic way. So we exercise some sort of filtering process based on what the witness has said in the statement and what we believe to be relevant. This chat that we're talking about is relevant only to disprove the answer that the witness has just given now, which we couldn't possibly have anticipated. And I'm not going to refer to the chat for any other purpose. The fact that the witness, that the informant comes from Pakistan is evident from one page of the chats. The starting date of the chats is evident from another page of the chats. I can give 2 pages to Mr. Ngwato and he can have all of the relevant information upon which I depend in relation to the chat between Sergeant Nkosi and this informant. But unless Mr. Ngwato wants us to give everything, and he's never asked for that, we have to exercise some sort of filtering principle. Otherwise, what we would dump on him would preoccupy him for weeks before he could be on top of it. So that's what I wanted to place on record.
Thank you, Mr. Chaskalson. Mr. Ngwato, I think we must separate issues. When you first raised an issue, it related to the questions that Mr. Chaskalson is putting to Sergeant Nkosi. But then you also raised another issue, and that is what I'm saying should be separated from the issue relating to the questioning now. That other issue is about the documents that you say were given to you only about a week or so ago. It seems to me that that issue is different, but also there's the question that Mr. Chaskalson puts before us, which is that those documents were actually given to you electronically quite some time back. I think he said 3 weeks ago?
No,
electronically.
The electronic link to all of the documents in the bundle was given 2 weeks ago.
Or 2 weeks ago electronically. And that is only later that they were given to you in a paginated form. So I'm saying all of that should be treated differently to the questions being asked now. Let me start with the questions being asked now. The questions being asked now, that issue to me is similar to what arose this morning. If you remember, that related to, was it a bank statement? I think it was. And how I resolved that was that that is an issue that arose because of answers given by Sergeant Nkosi. And it is those answers that took Mr. Chaskalson to the documents that you had not had sight of. And there is no way that we would then gag Mr. Chaskalson from going to documents that are relevant to answers given by the witness. And he had not shared those documents with you because, but for those responses, there was never an intention to use those documents. So it seems to me that what has arisen now with regard to this questioning is similar to that, and that it should be resolved in the same way, which is that you should be given, in fairness, you should be given those documents. But that can never stop Mr. Chaskalson putting the questions that he has been putting to the witness. And the witness has been able to respond. But the main issue, aside of the responses that the witness has given, the main issue is that Mr. Chaskalson is following that line based on responses that have been given by the witness. And I think it's only fair that he should be allowed to ask those questions. And that's the same ruling that I took this morning with regard to the other issue that arose this morning. Now, coming to the second issue, if you were given those documents electronically, the question that arises is, what did you do with them? You say you are seeing them for the first time now, so it means when they were given to you electronically, maybe you chose not to have a look at them altogether, because you would not be saying you are seeing them for the first time now if you had had a look, unless you are saying those were never even given to you electronically, as Mr. Chaskalson says they were. So if they were given to you, it's not the same if they were given to you electronically 2 weeks ago, and not only, did you say Friday last week? So the two are simply not the same. It looks like you want to respond.
I do, Commissioner.
Yes.
I do. I will not raise an issue with you if I'm not sure what I'm talking about. The documents were never shared with us. On the 3rd of March is when I responded to the affidavit that the Commissioner had requested that I should submit.
The new thing is sharing electronically. So I was saying they were never shared electronically
They
at
were
all,
never shared
at
with
all.
us at all. I printed everything that I received from them. And over the weekend, I took an effort to make sure.
Perhaps we should adjourn and let's see if there won't be proof of an exchange of emails, an exchange which does show that the documents were indeed shared electronically.
But can I at least maybe finish?
Yes. Please finish, Mr. Ngwato, yes.
And the reason I raise this issue is the continuing trend that every single time a line of questioning comes up, I allow the witness to finish answering it, but then becomes an issue of credibility at the end of the line of question to say, no, you are actually lying, what you're saying is false. Because if we pull out the following documents, we'll prove you wrong. And this is what led to the bank statements as well yesterday. This is what also came about Natasha yesterday to say, have you not paid up any money to Natasha? It's the same thing that also falls on today, Commissioner. Now, Mark, what I'm raising now is that in as much as accommodative as I want to be, it is getting too much that as we continue with the process, new documents are revealed and revealed. This morning I indicated to you, it was not just the bank statement, it was also written statements. And again, it was the manner in which it was tried to sneak into my file, giving somebody who's not even a member of the law firm to go and edit my files. And now I'm continuing with this type of a situation.
Was it really sneaking in? Let me tell you what happens to our files all the time, our files as commissioners. Because sneaking has negative connotations. What sometimes happens with our files is that the attorneys will come and will insert documents with us being aware, sometimes not, but that then gets brought to our attention. Was it not something similar where perhaps the attorneys perhaps not putting in additional documents to your files? I know, for example, that I think it was this morning as well. This morning as well with our files, additional documents were inserted into our files. Is that not what was happening with your witnesses' files or your clients' files or perhaps your clients' files? Just to see whether it was indeed sneaking in, as you put it.
The decency and the collegiality will require you come to me as an attorney of record. These are the additional records that we want to have. You don't go to my files without my knowledge and want to put in there. If I'm going to raise to say, didn't see this is in your file, then it looks like I'm failing in terms of my functions. And I also do not accept the comment to say, had I been given these documents, I will not have had time to go through it. The same complaint I raised with you, Commissioner, right from the beginning. If you give me 4,000 pages, I'm going to have to go through those 4,000 pages. Don't tell me I'm only going to focus on 100. I'm duty-bound once you give me 4,000 pages to go through all of them so that I don't have surprises. And this is what I kept on complaining from the beginning. Now, the issue that I'm simply raising right now was to say I have allowed the questions to go, but it was the statement that was issued or that was made to the witness at the end that what you are saying is false because you have been communicating with this witness for the last 14 months and this is based on the cell phone records, which I don't have. The witness could not have been in a position to answer that question because he has not been given the records. And if they wanted to make such a narrative, they should, in fairness, give the witness such a record first.
In practical terms, then, Mr. Ngwato, how do you suggest this should be resolved? That is, with regard to your access to documents. If you recall, let me again I've been referring to the 4,000 pages from yesterday already, but let me focus on that again for purposes of seeing how best this could be resolved in practical terms. You were given the 4,000 pages, and as part of your application for a postponement when we first started, you referred exactly to the fact that you had been furnished with 4,000 pages of documents. But Mr. Chaskalson said of those, he was going to use only 1,300 and something thousand pages. Now, if you had not only been given the 4,000, but the indication was also that all 4,000 pages would indeed be used, we would probably have started much later than we actually did. So what Mr. Chaskalson is saying is that they often use their own discretion with regard to what they consider to be relevant. I assume that that will be based on what the witness has said in their statement, and also on what other additional documents, in addition to the statement, the witness will have provided the evidence leaders, and also whatever it is the evidence leaders themselves consider to be relevant. But that does not mean that that will be all that they will be having in their possession. They may be having a lot more. It doesn't make practical sense for them to then dump everything that they have on the attorney or the client where the client is not represented. It is for practical reasons and also to expedite proceedings that they will choose what in their judgment they consider to be relevant. But proceedings being what they are, it may sometimes arise that other documents suddenly become relevant. In that case, fairness does dictate, and as you've correctly pointed out, that the documents should then be shared if and when that arises. So it is in that context that I'm asking you, practically, how do you suggest this should be resolved? Are you saying everything should be dumped on you? If not, how should this be resolved in practical terms?
Chair, dumping will not be the solution.
Yes.
Simply what I'm recalling is that if you are to refer to a particular document and you are aware that you have not shared that document, just give a heads up to say, this document I've not shared with you, and share the document with us. But to continue, and I continuously have to raise this aspect.
Yeah.
I was very clear when I met with them yesterday. I went back to them and say, I have noted that we have shared the following bank statements, but in your analysis you included extra years which you have not included in your bundle. Will you be so kind to provide us with that? They say, oh, we made a mistake. I expect the same collegiality from them, but I don't appreciate, and it cannot be fair that my client has been ambushed on documents that he had never had sight of, and he's been told, you are not telling the truth, because this goes into his credibility in terms of answering. He said from the beginning, I can't remember the dates, but I can give you a context in which I obtained that issue. The end of that aspect then becomes, you are not telling the truth because of in our records. Which records? We don't have. How do we argue against that? Because we don't have the records.
I agree with you 100% on the point you make with regard to documents that the evidence leaders can practically give you a heads up, but they do not do so. So I agree with you 100% on that. But I'll get Mr. Chaskalson to respond on that. That is with regard to whether they have indeed not given you a heads up where it was practical for them to do so. But I assume that you are not, in making that point, I assume that you are not referring to situations like the one that arose this morning and the one that has just arisen now, both of which arose from responses given by the witness in testimony, which then led to the evidence leaders making a follow-up and discovering that there are documents that relate to the answers that the witness has given. So there's a difference between the two. Mr. Chaskalson?
Chair, the situation is in fact different. On the 22nd of January, we gave Mr. Ngwato a memory stick with every chat we have, every single chat, including the chats that I've referred to today and hundreds of other chats. He has had every single chat we have since the 22nd of January. If he looks at that memory stick, he will find the chat with this informant. He needs to look for it by name. He'll find also the chats with General Mkosi. He's had all of these documents. We didn't believe they were going to be relevant until the witness presented certain answers. The answers of the witness rendered these chats relevant, and therefore we referred to them. The bundle was prepared on the basis of what we intended to canvass in cross-examination. Everything in the bundle was made available to Mr. Ngwato 2 weeks ago. The paginated hard copy versions of the bundle were only made available to him on the Friday. That is the situation. There's no prejudice to him. A witness can't be entitled to testify with impunity in relation to documents which his attorney has and which I have, but which are not in the bundle because until the witness testified down a particular line, we didn't anticipate the documents were going to be relevant. If Mr. Ngwato, I'm happy to leave this topic overnight and come back to it tomorrow morning if Mr. Ngwato needs to consult his own memory stick and look for the chat of the individual. If he wants us to print it out for him after proceedings, we can do that. But this complaint of prejudice is with respect completely unfounded.
May we, unrelated to this, take a comfort break, but perhaps like we did this morning, my direction would be for the questioning to continue. If after Mr. Ngwato has had a look at this, purely on the basis that this arises from the witnesses' responses, and I do not think we should stop the cross-examination. If Mr. Ngwato